अस्सलाम वालेकुम स्टूडेंट। लास्ट 2 क्लासेस में हम डिस्कस कर रहे थे फेडरल एक्साइज एक्ट 2005, जिसमें हम चैप्टर नंबर 5 तक पहुंच गए थे और हम डिस्कस कर रहे थे पावर एडजक्शन एंड अपील्स, जिसमें हमने अथॉरिटीज को देखा था। चीफ कमिश्नर इनलैंड रेवेन्यू, कमिश्नर इनलैंड रेवेन्यू, कमिश्नर इनलैंड रेवेन्यू अपील्स, एडिशनल कमिश्नर इनलैंड रेवेन्यू, डिप्टी कमिश्नर इनलैंड रेवेन्यू, District Taxation Officer Inland Revenue, Assistant Commissioner Inland Revenue, Assistant Director Audit Inland Revenue, Inland Revenue Officer, Superintendent Inland Revenue, Inspector Inland Revenue, Inland Revenue Audit Officers, and Officer of Inland Revenue with the other designations. Specify the function of jurisdiction of the direction Directorate General and its officer, and confirm the power of authorities specified in subsection 1 of the section 29 upon the Directorate General and its officers. The Director General Inland Audit shall consist of the Director General and as a many director, additional director, deputy director, and assistant director and other officers with the other designation as the board may appoint by notification in the official gazette, and the Director General of Training Research shall consist of the Director General and as many director, additional director, deputy director, and assistant director and other officers with the other designation as the board may appoint by the notification in the official gazette. The board may be notification in the official gazette and subject to such limitations or condition as may be specified in own power by name of designation. Any additional commissioner inland revenue or deputy commissioner inland revenue to exercise any of the power of commissioner inland revenue. Any deputy commissioner inland revenue or assistant commissioner inland revenue to exercise any of the power of an additional commissioner inland revenue. Any assistant commissioner inland revenue to exercise to any other power of the deputy commissioner inland revenue, and any other officer of inland revenue to exercise any other power and commissioner inland revenue additional. Commissioner Inland Revenue, Deputy Commissioner Inland Revenue, Assistant Commissioner Inland Revenue under this Act and rules made thrown under. 5. The officer to whom any power of any senior officer are delegated under this section shall not further delegate such power. Use of power subordinate officers. An officer appointed under this Act shall exercise such powers and discharge such duties as are confirmed to impose on his under this Act, and he shall also be competent to exercise all power and discharge all duties or functions conferred or imposed upon any officer subordinate to him. Notwithstanding any content in this Act or the rules made thereunder, the board may by journal or special order impose such limitation or condition on his exercise of such power and discharge of any such duties by any officer inland revenue is deemed fit. Option to pay fine in lieu of compensation of conveyance whenever compensation is subjected under this act or the rules made there under The officer adjusting it may give the owner of the conveyance an option to pay in lieu of compensation such fine as the officer thinks fit. Appeal Commissioner appeals. Other than federal excise officer aggrieved by any decision or order passed under this act or the rules made thereunder by the officer inland revenue up to the rank of additional commissioner inland revenue other than decision or order to notice given or action taken for recovery of the errors of the duty under this act or rules made there under may within the 30 days of the receipt of such decision or order prefer appeal therefrom the commissioner appeals. Where in a particular case the commissioner appeal is of the opinion that the recovery of the tax levied under this act shall cause under the hardship to the taxpayer, he after affording opportunities opportunity of being heard to commissioner or officer inland revenue against whose order appeal has been made may stay the recovery of such tax for a period not extending 30 days in aggregate. An appeal under the section 1 shall be in the prescribed form, be verified in the prescribed manner, state precisely the ground upon the appeal is made, be accompanied by the prescribed fee specified in the subsection 1C and be filled with the commissioner appeal with the time set out in the subsection 1. The prescribed fee shall be in case the appeal against the assessment where the appellant is company or of 5,000 rupees or where the appellant is not a company 2,500 rupees and in the other case where the appellant is a company 5,000 rupees or where the appellant is not the company 1,000 rupees. The commissioner appeals may, after giving both parties to the appeal an opportunity to being heard, pass such order as the thing fit confirming, varying, altering, setting aside the annulling the decision or order appeal against, provided the such order shall be passed not later than 120 days from the date of the filing of appeal or within the such extended period not extending 16 days as the commissioner appeals may for reason to be recorded in writing extended, provided further that any period during which the proceedings are adjourned on account of stay order or alternative dispute resolution proceeding or time take throughout the judgment by the petitioner not exceeding 30 days shall be excluded for the computation of this period. Third, in deciding an appeal, the commissioner appeals may make such further inquiry as may be necessary provided that shall not remain in case for novo considerations. The commissioner appeal shall not admit any documentary material or evidence which was not produced before the officer inland revenue under the commissioner appeal is satisfied that the appellant was prevented by the sufficient case causes from producing such material and evidence before the officer inland revenue. Appeals to the appellant tribunal. Any person or officer of Inland Revenue aggrieved by any of the following order and within the 60 days of the receipt of such order file appeal to the appellant tribunal against such order. An order passed by the Commissioner Appeals and an order passed by the Board of the Commissioner Inland Revenue under Section 35. Provided that the appellant tribunal shall decide that appeal filed under this subsection within 6 months or its filing of appeal. The appellant tribunal may admit, hear and dispose of the appeal as per procedure laid down in section 131 and 132 and Income Tax Ordinance 2001 and rules made thereunder. Reference to High Court with 19 days of the communication of the order of the appellant tribunal under subsection 2A of the section 34, the aggrieved person or commissioner may preference applications in the prescribed from along with the statement of the case. The High Court is stating question of law arising out of such order. The statement of the High Court referred to in subsection 1 and shall set out the fact determination of the appellate tribunal and the question of the law which arise out of its order. Where on an application made under the subsection 1, the High Court is satisfied that a question of law arise out of the order referred to in subsection 1, it may proceed to hear the case. 4. A reference to the High Court under this section shall be heard by bench of not less than 2 judges of the High Court and in respect of the reference that provision of section 98 the Code of Civil Procedure 1908 Act shall apply. High Court, upon hearing a reference under this section, shall decide the question of law arise by the reference of the passage judgment thrown thus specifying the ground on which such judgment is based and tribunal order shall be modified accordingly. The court shall send a copy of the judgment under the set of the court of the appellant tribunal. Notwithstanding that the reference has been made to the High Court, the tax shall payable in accordance with the order of the appellant tribunal. Where recovery of the tax has been stayed by the High Court by an order, such order shall cause to have effect on the expiration of the period of the 6 months following the date on which it was made, unless the appeal is decided or such order is withdrawn by the High Court earlier. Section 5. The Limitation Act 1908 shall apply to the application due to the High Court under the subsection. An application under the subsection 1 by a person other than the Commissioner shall be accompanied by fee or 100 rupees. Power of the Board Commissioner to the pass certain order. The Board or the Commissioner within his jurisdiction may so moto call for the examine the record of any proceeding under this act the purpose of the satisfying itself or as the case may be himself said to the legality or property propriety of any decision or order passed by the subordinate officer and the pass such order as it or he may think it fit. No order constructing goods of greater value of enhancing may fine or imposing the enhancing any penalty or requiring payment of any duty not levied or short levied shall be passed under subsection 1 unless the person affected thoroughly thereby has been given an opportunity of showing cause against it and being heard in person or throughout the counsel or other person duly authorized by him. No record of any proceeding relating to the any decision or order passed by any officer or inland revenue shall be called for examined under subsection 1 after the expiry of 2 years from the date of such decision or order. For the purpose of the section 35, 45 and 46 and the removal of the doubt, it is declared that the power of the board commissioner or officer of inland revenue under this section are independent of the power of the board under section 42B and nothing contained section 42B restrict the power of the board commissioner officer inland revenue under this section or to conduct the audit under these sections. Power to rectify mistakes in order. The federal government and board of or any officer in the revenue may rectify any mistake which is apparent from the record in any order passed by it or him under any of the provision of this act or the rules made there under on its or his own motions or on the applications made by the person affected by the order within a year of the passing of the such provided that no such rectification which has the effect of the enhancing any penalty or fine or requiring the payment of a greater amount of duty shall be made unless the person affected by the pause's rectification has been given an opportunity or being heard. Deposit pending appeal of the duty demanded or penalty levied. Wherein any appeal decision or the order appeal against the relates to any duty demanded or penalty imposed under this act, the person desirous of appealing against such decision or order shall pending the appeal deposit the duty demanded or the penalty imposed provided that the appellant tribunal or commissioner appeal may in any particular case dispenses with such deposit subject to the condition as it may deem fit to impose as to the safeguard the interest of revenue. The order for such dispensation under subsection 1 shall cases to have effect the expirations of period of 6 months following the date on which order of dispensation was passed or until the order of dispensations is withdrawn earlier or the case is finally decided earlier by the appellant tribunal commissioner appeal. Notwithstanding subsection 1 and 2, the appellate tribunal or commissioner appeals may direct that pending decision on the appeal the duty demanded or penalty imposed along with the default surcharge payable under this act be paid by the appellant in suitable installment spread over a period not exceeding 6 months from the date of the such direction, provided that where a person has at the time of filing appeals deposited 15% of the liability covered under the decision or order appeared against, he shall not be required to separately seek stay against the recovery, and stay in such a case shall commence from the date of the payment of such 15% amount and shall remain valid till the expiry of the period of 6 months or till the decision of the appeal, whichever is earlier, unless the case is decided in the favor of the amount so paid is claimed to have become due for refund. Provided further that the Commissioner Inland Revenue or any officer inland revenue subordinate to him shall not issue notice under this section or recovery rules made under the Federal Excise Rule 2005 for recovery of the tax due from the taxpayer if said taxpayer has filed an appeal under the section 33 in respect of the order under which the tax sought to be recovered has become payable and appeal has not been decided by the Commissioner appeals subject to the condition that 10% of the said amount of the tax has been paid by the taxpayer. Alternative dispute resolution, notwithstanding any other provision of this Act or the rules of the reformed and aggregate person in the connection with the dispute pertaining to the liability of the duty against of the aggregate person or the admissibility of refund as the case may be, to extend the waiver of default surcharges and penalty or any other specified relief required to resolve the dispute may apply to the board of the appointment of a committee for the resolution of any hardship or dispute mentioned in detail in the application which is under the litigation in any court of law or any appellate authority except where the criminal proceeding have been initiated or where the interpretation of question of law having effect identical case involved having effect on other case. The board may, after examination of application of an aggregate person, appoint a committee within the 16 days of receipt of the such application in the board comprising Chief Commissioner Inland Revenue having a jurisdiction over the case and two persons from the panel notified by the board comprising of chartered accountant, cost and management accountant, advocates having minimum of the 10-year experience in the field of the taxation and reputable businessman. The board shall communicate the order of appointment of the committee to the court of law or appellate authority where the dispute is pending and the commissioner. The committee appointed under the subsection 2 shall examine and issue and may, if it deem necessary, conduct inquiries, seek expert opinion, direct and officer of the Inland Revenue or any other person to conduct the suits and shall decide the dispute throughout the consensus with the 120 days of its appointment. The committee may, in case of the hardship, stay recovery of the payable in respect of the dispute pending before it for a period not exceeding 120 days in aggregate to till decision of the committee or its dissolution, whichever is earlier. The decision of the committee under subsection 4 shall be binding on the commissioner when the aggrieved person being satisfied with the decision, he withdrawn the appeal pending before the court of law and appellant authority and has communicated the order of the withdrawal to the commissioner, provided if the order of withdrawal is not communicated to the commissioner within the 16 days of the service of decision or the committee upon the aggrieved person, the decision of the committee shall be binding on the commissioner. If the committee failed to decide within the period of the 120 days under the subsection 4, the board shall dissolve the committee by an order in writing and the matter shall be decided by the court of law or appellant authority where the dispute is pending. The board shall communicate the order of dissolution to the court of the law, the appellant authority and commissioner. The aggrieved person on the receipt of the order of the dissolution shall committee is to be court of law, the appellate authority where the dispute is pending. The aggrieved person may make the payment of the federal excise duty and other taxes as decided by the committee under subsection and all the decision and order made the past shall stand modified to the extent. The board prescribes the amount of to be paid as remuneration for the service of the member of the committee other than the member of the appointed under clause 1 of subsection 2. The board may by notification in the official gazette make rules the carrying out the purpose of subsection. Exclusion of the time taken for copy in computing the period of limitation is specified for an appellant application under this chapter, the day on which the order complaint was served, and if the party preferring the appeals to making an application was not furnished with a copy of the order when the notice of the order was served upon him. The time required to obtaining copy of the such order shall be excluded. Supplemental provisions. The power of the board to make the rules. The board may make rules to carry into effect the purpose of any or all the provision of the act, including the charging fee of processing of written claim and other document and for the preparation of copies thereof. In making rules under this section, the board may provide that any person committing a breach of any rule shall, without prejudice to any order action that may be taken against him under this act, be liable to such penalty as may be prescribed under the rules and that any article in respect of which any such breaches is committed shall be confiscated or destroyed. The board may respect of regulate and make the rules to issue the instructions for the purpose of the affecting duty stands and under bundle laws and any instruction issues in this behalf shall have the forces of the rules issued under this act. Bar of the suits and limitation of the suits and other legal proceeding not suit shall be brought in any civil court to set aside or to modify any under the past or any assessment levies or collection of the any duty under this act. No suit prosecutions or other legal proceedings shall lie against the federal government or against the officer of the government in respect of any past in good faith or any act in good faith done or ordered to the done under this act, notwithstanding anything in the other law of the time being in force. No investigation or inquiry shall be undertaken or initiated by any governmental agencies against any officer or official of anything done in this official capacity. Under this act, the rules, instructions, or direction made or issued thereunder without the prior approval of the board. Observance of the board order, directions, and instructions, all officers and persons employed in the execution of this act and rules made thereunder shall observe and follow the order, directions, and instructions of the board provided that no such order, direction, or instruction shall be given by the board as so to interfere with the discretion of an officer in deciding the issue on matter brought before him for education under this act or rules made thereunder. Reference to authorities. Any reference to collector, additional collector, deputy collector, assistant collector, superintendent, and officer of the federal excise wherever occurring in this act and the rules, notification and clarification, journal order or order made or issued thereunder shall be constructed and as reference to the Commissioner Inland Revenue, Additional Commissioner Inland Revenue, Deputy Commissioner Inland Revenue, Assistant Commissioner Inland Revenue, Superintendent Inland Revenue, and Officer Inland Revenue, respectively. Selection for the audit by the board. The board may select person or class of the person for audit of records and documents throughout the computer bullet, which may be random or parametric as the board may be deemed fit. Notwithstanding anything contained in this act or any other law for the time being in force, the board shall keep the parameters confidential. Audit of the such person selected under subsection 1 shall be conducted as per the procedure given in section 46 and all the provision of act shall apply accordingly. For the removal of the doubt, it is hereby the declare the board shall be deemed always to have had a power to select any person or classes of the person for audit. 42C reward of inland revenue officer and officials. One in the case involving the concealment or evasion of excise duty and other taxes, cash reward shall be concerned to the officer and officials of Inland Revenue for the meritorious conduct in such cases and the informer providing credible information leading to such deduction, as may be prescribed by the board or after the realization of part of whole of the taxes involved in such cases. The board may be notifications in the official gazette prescribe the procedure in his behalf or specify the ap- apportionment of the reward sanctions under the section for the individual performance or collective welfare of the officer and official of Indian Revenue. Reward to whistleblower, the board may sanction reward to the whistleblower in case of the concealment or evasion of their duty, corruption or misconduct, providing credible information leading to such deduction or evasion of duty. The board may, by the notification in the official gazette, prescribe the procedure in behalf and also specify the apportionment of reward sections under this section. The whistleblower. The claim of reward by the whistleblowing shall be rejected. The information provided is of no value. The board already had the information. The information was available in public records or no collection of duty is made from the information provided from which the board can pay the reward. 43. Removal of the difficulties and conduction of the Time Limit Act. If difficulty of the or situation arise in giving the effect to the applying the provision of this act or rules made or notification issue thereunder, the board may throughout a general order to otherwise issue the construction or direct direction for the such action to be taken by an officer, federal excise, any other person as if considered the necessary to expedient for the purpose of the removing the difficulty or taking such situation and even every such officer or person shall be bonded to comply with the instructions or direction in issue manner as may be specified below. Where any time or the period has been specified under any of the provision of this act, the rules made there under within which any application is to be made or any act or thing is to be done, the board may in any case or class of cases permit such application to be made or such act or thing to be done within the such time or period as may be considered appropriate provided the that the board may subject to the such limitation or condition as may be specified on empower any commissioner or other officer of inland revenue to exercise the power under this subsection in any case of class of cases. For the purpose of this section, the expressions may act a thing to be done include any act or thing to be done by the registered person or by the authorities specified in section 29 of this act. Issuance of duplication of federal excise documents An officer of the Federal Excise not below the rank of the Exception Collector any on the payment of the 100 rupees issue and attested the duplicate of any deferred exercise document as it available with the dependent or has been failed under this act or rules made thereon under to relevant registered person applying for the same. Refund of duty, not refund of any amount of duty according occurred for the reason under the act or rules made thereunder shall be allowed unless the claim within 1 year or its accrual. In a case where a registered person did not avail the adjustment of the duty admissible at the relevant time that the commissioner may allow such person to avail the adjustment of any subsequent time provided that claim. For such adjustment, it's made with the period of the 1 year from the date on which was admissible. In case where the claim for refund or adjustment has occurred in the consequences of any decision or judgment of any federal excise officer, the tribunal of court, the period of 1 year for the purpose of this section shall be computed from the date of such decision or judgment. Delay refund, where a refund due under Section 44 is not made within the time specified in the behalf, they shall be paid to the claim in the addition the amount or refund due to him of further sum equal to Caibor per annum of the amount of refund due from the date following the expiry of the time specified as refers to the day preceding the day of the payment of refund, provided that where there is a reason to believe a person has claimed the refund which is not admissible to him, he shall not be entitled to additional amount unless the investigation of the claim is completed. Access to record and deposit of Excise Staff Act. A person who is required to maintain any record or document under this Act or any other law shall as and when the required by the officer of Inland Revenue produce record and document which are in the position or control or in the position or control of his agent and where such record or document have been kept on electronic data, he shall allow access to the such officer to have access and use of any machine on which such data is kept and shall facilitate such officer to retrieve whole or part of the such data in such manner and so such extent to may be required by him. Subject to such condition and restriction as deemed fit in specify the board omitted may pose the officer of Inland Revenue to the premises of the registered person or the class of the such person to monitor production of removal or seal of goods and stock position of the maintenance of records. The board made notification in the official gazette for the purpose of the monitor production or manufacture of any goods, specify the manner and procedure for appointment and posting of the technical staff and installation, operation, maintenance of glass circuit TV system anywhere in the factory premises. Monitoring or tracking the by electronic and other means subject to such conditions, restrictions, and procedure as it may deem fit to the impose or specify. The board may notification on the official gazette specify any registered person or class of registered person or any goods or class of goods in respect of which monitoring or tracking of production, sales, clearance, stocks, or any other related activity may be implemented throughout the electronic or other means or may be prescribed. From such data as may be prescribed by the board of the accessible goods shall be removed or sold by the manufacturer or any other person without the affixing tax stamp, model roll, stickers, labels, broadcast act in such from the style and manner and may be prescribed by the board of this behalf. Such tax stamp, model rolls, sticks and labels and barcodes acts shall be acquired by the registered person referred to the subsection 2 from the license appointed by the board of the purpose against the price approved by the board which shall include the cost of equipment installed by which license in the premises of the said registered person. Audit the officer of Indian Revenue authorized by the board chief commissioner by designation may be once in a year after giving the advance notice in writing conduct audit of the record and document of any person registered under this act. In case of commissioner has information or sufficient evidence showing that the such registered person is involved in fraud or evasion of duty, he may authorize to federal excise officer and not below the rank assistant commissioner to the conduct audit at any time in a year. After the completion of the audit under this section, or may other provision of law, officer of Indian Revenue may, after obtaining the registered person explanation on all the issues raised in the order, shall pass an order under section 4 imposing the amount of the duty as per law, changing default surcharges, imposing penalty and recovery of any amount previously referred. Notwithstanding penalty prescribed in section 19, if a registered person wishes to deposit the amount of duty not paid, short paid, or the amount of the duty evaded along with the default surcharges voluntarily whenever it comes to the notice before the commencement of the audit, the penalty shall be recovered from him, provided that if a registered person wishes to deposit the amount of duty not paid in short paid, the amount duty evidence along with the default of surcharges during the after the audit before the determination of the liability under subsection 2A conclusion of the original adjustment proceeding, he may deposit the amount along with the 25% of the amount of the penalty prescribed under this act. The rules of the there under and in such case further the proceeding in the case shall be. The board may appoint as many special audit panel as may be necessary, comprising two or more members from the following: an officer or officer of Inland Revenue, or officer of Chartered Accountant as a defined under the Chartered Accountant Ordinance 1961, a firm of cost and management accountant as defined under the Cost and Management Accountant Act 1966, any other person as directed by the board to conduct audit or registered person, a person including audit of refunding claim and forensics audit, and the scope of such audit shall be determined by the board or the commissioner in the revenue on a case basis. In addition, the board may, where it consider appropriate, also get such audit conducted jointly with the similar audit being conducted by the provincial administration of the sales tax on services. Each special audit panel shall be headed by the chairman, who shall be an officer of Inland Revenue. If any one member of the special audit panel other than the chairman is absent from the conducting of the audit, proceeding of the audit may continue and the audit conducted by the special audit panel shall not be invalid or be called in the question merely on the ground of such absence. The board may prescribe the rules in respect of the construction constitutions, procedure and working of a special audit panel. Every member of the special audit panel shall have the power of the officer of Inland Revenue under section 23 and 45 and subsection 1 to 3 of section 46. The audit of the registered person shall generally be composite audit covering all the duties and taxes to which his business or activity is liable under the law administered by the board. Service of the notice and other documents subject to this act, any notice, order, requisition required to the serve on the resident individual other than in the representative capacity for the purpose of this act shall be threatened as properly served on the individuals. Personally served on the individual, or in the case of an individual under the legal disability or non-resident individual or representatives as defined in section 172 of the Income Tax Ordinance 2001 of the individual. Send register post and courier service to the place specified in clause of subsection 2 or to the individual's usual or last known address in the Pakistan, or serve on the individual in the manner prescribed by the service of the Summon under the Code of Civil Procedure 1908 Act. Send electronically throughout email or to the e-folder maintained of the purpose of the e-filing or sales tax cum federal excise return by the registered person. Subject to act, any notice, order or requisition required to the serve any person other than the resident individual to whom subsection applies for the purpose of the act shall be treated as properly served on. Personally served for the representative of the person sent by the registered post or courier service to the person's registered office or address for the service of the notice under this act in Pakistan, or where a person does not have such office or address, notice is sent by the registered post to any officer of the place of the business of the person in Pakistan. Serve on the person in the manner prescribed for the service of the convenience under the Code of Civil Procedure 1908. Send electronically throughout the email or to the folder of the maintained for the purpose of the e-filing sales tax cum federal excise written by the registered person. Where association of the person is dissolved, any notice order requisition required to be served under this act on the association may be served any person who was a principal officer or a member of the association immediately before the dissolution. Where business stand discontinue and any notice order or requisition required to be served under this act on the person discontinuing the business may be served on the person personally or individual who was the person or representative of the time of discontinuation. Discontinuous. The validity of any service of the notice under this act shall not be called into question after the notice has been complete with any manner. Agreement for the exchange of information. The federal government may enter into bilateral or multilateral agreement with provincial government on the government of the foreign countries for the exchange of information, including electronic exchange of information with respect of excise duty imposed under this act or any other law Pakistan or under the corresponding law of the country and may notification in the official gazette make such provision as any be necessary for implementing such agreement. The provision of section 107 of the Income Tax Ordinance 2001 shall witness the Montres apply to this section. Disclosure of information by the public servant. Any information acquired under any provision of this act shall be confidential and no public servant shall disclose any such information except the provided under the section 216 of the Income Tax Ordinance 2001. Notwithstanding anything contained in the subsection 1 and the Freedom of the Information Ordinance 2002, any information received or applied in pursuance or bilateral or multilateral agreement with the government of foreign countries for exchange of information under the section 47A shall be confidential. Validation. All notification and order issued and notified in exercise of the power upon the federal government before the commencement of the Finance Act 2070 shall be deemed to have been validly issued and notify in exercise of those powers. Notwithstanding any omission, irregularity, or deficiency in the establishment of the conferment of power functions on the Directorate General Intelligence and Investigation in Revenue and authorities specified in Clause A of subsection 2 of the Section 29 of this Act. All the order passed, notice, issue, and action taken in the exercise or purported exercise of the power of the function of the officer of Inland Revenue under this Act by Director General Intelligence and Investigation Inland Revenue or the authorities specified in clause or of the subsection 2 and section 29, this act shall be treated to have been validly passed, issued, and taken under this act. Repeals subsection to the provision of subsection 2 and the Central Excise Act 1944, one of the 1944 shall stand repealed with effect from the date notified under the subsection 3 of section 1, unless otherwise directed by the federal government in case of the area where the repeal act the extended throughout an order by the government of the province of the otherwise throughout the order by the any other authority. The application of the repeated act shall continue to be forced till this act in the made applicable in the area in that area. Fee and service charges board with the approval of the federal minister in charge may be notification in the official gazette subject to such condition, limitation or restrictions as it may deem fit to impose levy, fee and service charges for valuations in respect of any other service of the control mechanism provided by the formation under the control of the board, including the ven- ventures of the public-private partnership and such rates as may be specified in the notification.